This is a current trends case brief of the criminal case R v. Malmo-Levine, which deals with the application of the harm principle. The citation is R v. Malmo-Levine, 2003, SCC 74. Facts. Malmo-Levine ran a non-profit corporation helping people reduce the harms associated with marijuana and teaching them safe practices. His clinic was searched by police and a large amount of marijuana was found. Malmo-Levine was charged with possession and trafficking of marijuana, contrary to Sections 4 and 5 of the Controlled Drugs and Substances Act, respectively. The accused challenged the constitutional validity of the prohibitions by arguing that the harm principle requires any criminal offense to be designed to prevent harm to society. There were two main issues involved in this case. Firstly, do all crimes have to adhere to the harm principle? And if so, are the prohibitions on the personal use of marijuana constitutionally valid? The decision of the Supreme Court of Canada was that the appeal should be dismissed. Rationale, Issue 1. Malmo-Levine argued that all crimes must adhere to the harm principle from the philosophical writings of John Stuart Mill. This theory essentially states that the only reason the state should be able to intervene in one's actions is if they are causing harm to others. He argued that because the possession of marijuana for personal use does not cause harm to others, it cannot be prohibited. Justices Gonthier and Bin, writing for the majority, decided that this claim is ungrounded, as there is no principle stating that all laws must adhere to the harm principle, and further, that there are several crimes in the criminal code that do not harm others, such as cannibalism or any other indecent interference with a deceased human body, which is contrary to Section 182. They decided that the harm principle is not a fundamental aspect of our justice system, and therefore its violation does not lead to the prohibitions being unconstitutional. They also rejected the argument that other things that are more harmful, such as cigarettes and alcohol, are not prohibited. They say that despite this, the legislature was not outside their boundaries in prohibiting marijuana because it has different effects than those other substances. Issue 2. After ruling that crimes do not have to adhere to the harm principle, the court had no basis upon which to rule that the prohibition of the personal use of marijuana is unconstitutional. Analysis. Although many criminal prohibitions may be based on the harm principle, it is not a fundamental aspect of our justice system and is not needed to be included in crimes for them to be constitutionally valid. One of the primary purposes of our criminal legal system is the protection of society, and with this ruling, the court has endorsed the view that such protection includes protecting individuals from their own dangerous or immoral acts. Survey question. Do you agree that the government should prohibit the mere possession or use of certain harmful drugs? Please respond yes with a check mark or no with an X. Thank you.